What we're dealing with here is a total lack of respect for the law.
Most people think about judges and lawyers when they are asked to describe law, but law is defined in one simple way. Law is a rule or rules that limit behavior of the individuals who accept those rules. These rules are enforceable through penalties by the community that accepts these rules. The need for law only applies when someone is in conflict or controversy with another. And there is a distinct difference between what is legal and what is lawful. Lawful means an act which does not create controversy. No one can be caused a loss or an injury for something to be lawful. If you drive down the road and you hit someone with your car, you are not operating lawfully. If you steal another man's property, you are similarly outside of lawful behavior. But if you destroy your own property or give your property away freely, this is a lawful act. In America, we are lawfully free to travel without restriction, have the right to secure our own property, the right to bear arms, to speak freely, and more importantly, all men are equal under law and have the right to be free in life, liberty, and the pursuit of happiness. This means that feeding your family and securing a homestead of some kind are rights, and these cannot be taken from you without your consent. But if you choose to give up these rights, there is no law that prevents you from entering into some other kind of law structure that will give you privileges instead of rights. And consenting to this sort of treatment has become a common procedure today. This takes us to the definition of legal. Legal behavior is framed within codes of conduct or guidelines that are set by an authoritative body such as the government. Under a legal system, you are not free to exercise rights such as a lawful system of operation would provide. A legal system takes away rights and supplants them with privileges. But you do get benefits from such a system. You no longer have to be capable of presenting yourself in court. No one can enslave you directly from your debts to that individual under a legal code. Everyone in legal terms is bound to a representation rather than appearing to the court directly. The legal system provides insurance to the individual that is operating within the code. It limits each man's liability to each other and restricts harsh punishment. Nearly everyone alive today accepts a legal system to provide for litigation and compensation due to the ignorance of law at large by the average individual. We need to come to an understanding of what the structures of law are and where they stem from. Then we can develop a more comprehensive view of how law is used to create and control the commercial, financial, and institutional systems that fall within its grasp. The first form of law that we can find from ancient times is the laws of God, or the laws of nature. Regardless of your view on a God or no God, we can all agree that we came from a natural setting, from this world as natural creatures, and born the same way. From this idea we can see that all men surely are created equal. So each man should have the ability to exist without limitations, as long as he does not create problems for another man. The ability to exist and continue existing by feeding yourself and others, or providing a roof over their heads, all comes from natural law. This is the basis of the Ten Commandments, other forms of religious law, and most of all, contract law. It's the primary source for all doctrines of law, and the rules of natural law are specifically shown in the Roman law maxims. A maxim is precedent for any other law to be formulated. Therefore, any law maxim may be applied to one's rhetoric, to intelligently reason and contract from. These law maxims were engineered through extensive thought and philosophical examination of certain situations that men find themselves in. Natural law is the ability of a man to do as he wishes while remaining respectful of other people's wishes. As long as you don't take from others or cause them harm, then natural laws have not been broken. From this point, contract law is created to give men a way to deal with each other fairly in trade and commerce. Contract law simply means if two men agree on a trade or a method of operating together for a common purpose, then no other man or body of law may interfere with this dealing or contracting. It doesn't matter if one man offers the other 10 bars of gold for the other man's single loaf of bread. If they agree on this trade, then they must supply each other with these goods in the proportion agreed upon. If one man agrees to work for another over a week period for the payment of 10 carats, then the man must work the whole week, and the other man must pay the 10 carats. It doesn't matter if the deal is lopsided or uneven, fair or unfair, because each man agreed to the arrangement of their own free will under natural law, and neither are harming anyone in the process. Contract law doesn't require a written document either. An expressed or implied contract is even more binding than a written one. The written document is simply a memorial of the agreement, and it creates a guarantee in case of someone defaulting on their promise to perform. The paper document could not have any power were it not for the agreement or the contract that the paper expresses. Contract law is a method of communication between parties based on a few principles. Each party must offer consideration to each other. This consideration is some sort of item, service, value, or worth. Consideration is what each man brings to the table for the agreement. A loaf of bread is consideration from one party, while a chicken could be consideration from the other party. If both men agree to the trade and make the exchange of consideration, then there is nothing either man can do if they later on decide that the deal was a poor one. Each party must also bring full disclosure to the table. Each man must discuss all aspects of the deal and are bound to disclose any detail that may affect the performance of the contract. If you promise to bring 10 carats to a man in the future for a loaf of bread right now, and the other man asks how long it will be until your carats are ready for the harvest, you must give a timeline for the delivery of the carats. You can't just promise something in the future, and after the deal is made say, "Well, I said in the future, but I meant in 20 years. This would be unacceptable in contract law unless you specifically made it clear that the carats would not be delivered for 20 years. And if you did give this information to the other party and they still accepted the offer, you would be in the clear and operating lawfully. On the other hand, if you never do provide the carats at the agreed upon time, then the other party can try to get remedy in law for your non-performance. The most important aspect of contract law is offer and acceptance. Your offer to another man is accepted and you both make an exchange. The other man might counteroffer, asking for more out of the deal than your original offer, and you can then accept the counteroffer or continue haggling over the details of the exchange. Once an agreement is made, a contract is formed, and both parties must perform their end of the bargain. There are 4 main ways to deal in contract law with respect to the offer and the acceptance. Mutual assent is where an original offer is accepted as is. Counteroffer or conditional acceptance is where the offer is modified and returned back to the original offerer with different conditions. Acquiescence is where the offer is neither accepted nor refused, usually distinguished by silence or inaction. Refusal is, of course, where the offer is rejected and not accepted under any circumstances. So why are these 4 ways of dealing with an offer important to us? They show a basic format of respect and understanding under honorable terms. Everyone must understand the meaning of honor before we can go any further. If you agree to an offer, you are always in honor. It is the respect of one man to another of their performance in that situation. If you conditionally accept or counteroffer someone, you are not refusing them, but instead you're working with them in your own best interest to come to an agreement and an acceptance. If you remain silent or acquiesce, it's a sign that you either do not understand the offer or you're disinterested in the communication another man is attempting to bring to you. Silence is a sign of disregard to another man and brings dishonor with it. If you pretend someone doesn't exist, chances are they will not like you very much or honor your wishes. Refusal is the big dishonor. You see the other party offering a deal to you, but you will not deal with them under any conditions. You have closed off any reasoning, counteroffer, or other conditions to remain in honor, and instead you have decided to dismiss whatever value might be offered. What we have been missing here in our understanding is the presence of contract in all communications, no matter how small or insignificant we may think of them. Every interaction in life, every time that we communicate with other people, we do so with the action in the offer and the acceptance from the other people around us. The 4 ways of dealing with an offer are the only ways to interact with other people. We can accept others' actions, refuse them, remain silent, or come back to them with some sort of counteroffer. We have lost sight of these simple principles in everyday life. They have value and they speak to the true intent of a man. Someone who accepts others and their opinions will have an easy time being accepted by and respected by others. Those who refuse others' thoughts or are in conflict with others on a regular basis will find that they have little to no respect in the other people they find themselves around. And those who do not respond at all will also find themselves to be dishonored. If you can't respect others, then they won't respect you. It's that simple. And this is the real premise behind almost all forms of law. It's a give and take, or an equality that men are trying to reach, an equivalence of considerations. And this is why the scales of judgment are so very important symbolically. You place your offer on one side of the scale, and the other party places something they feel is equal in consideration of your offer. When one side does not equal the other, you have a conflict of interests, and you are in your own right to try and get a remedy to the imbalance. All of that just to set you up for the 2 main forms of law accepted today. You really should rewind this film and clearly understand what I'm saying here. I'll give some resources at the end of this chapter so you can study further and find more clarity in law. I have to be short on words, so I'm offering you just the fundamentals of how the Clockmaker set this system up. It's up to you to research this material for yourself, but with the concepts I'm providing, it should be much easier to interpret most law forms for what they are. Now we're going to move on to the law of the land. This is the law of the people. It's law that's determined by a community of some sort where certain things are prohibited. It's law that is common to all men from that community, so it's called common law. As Jordan Maxwell always says, you can do things in France that you can't do in China. You can do things in China you can't do in Saudi Arabia. If all the people in a given community are agreeing that a particular act is not within common decency, then they can apply force to stop that act. But if an act does not offend the community, then there is no reason to react and put a stop to it. Common law is associated with the creation of the Magna Carta of 1215. Groups of people, along with the Pope, agreed that the King of England must give certain rights back to the people, under Roman maxim and contract law principles. This was a double-edged sword like most law forms. The people who conspired with the Pope were well-to-do, wealthy, influential members of higher society who were seeking freedom from the tribute that was paid to the king. Exposing a doorway of freedom to all men did not mean that all men would be free. In fact, it only provided a logical, rational framework of wisdom that one could use to free themselves if they can understand it. Common men did not understand the rules of playing games on the court of law, as they had never been exposed to the schooling and grooming that would be needed for the understanding of law, and even more importantly, how to effectively communicate with logic and rational thought. Instead, most people have an instinctual drive of emotion and feelings that compel them into dishonorable and conflicting communication. It's like a man walking into a poker game not knowing the etiquette needed to play. You will lose all of your bets. And these people who helped create the Magna Carta were fully prepared for uninformed, ignorant masses to be given this freedom. In this way, each man was now free to contract any way he pleases, and alternative social offers could be created for those people who could not reasonably contract. Well, this brings me to the meaning of response and reaction. One who responds uses logic and wisdom. They are in honor since they did not remain silent. Responsibility is one who responds to offers made to them, one who is willing to communicate and be respectful. Reaction is the opposite of response. Reaction is acting without any reasoning or respect. It is self-preserving and self-absorbing, acting in fear, hate, anger, love, fight or flight, elation or obsession. One is bound only to their self and no longer to the concerns or respect of others. Reaction is simply giving in to emotions or animal instincts. If you can't reason with a man, then he is to be looked upon as an animal. A man who acts as an animal must be treated as one. If a man cannot control his actions and gives in to feelings and drives, then he will be externally controlled through law, and law takes this concept to its extremes. Any reaction given to authorities automatically places that individual under the care and dominion of that authority. An authority is the author of the writ. It is he who writes the law, and it is each individual that decides what law is. If you choose to let some other guy author your writs, then it is he who holds authority over you. One must remain in their own intellectual and moral capacity at all times if they wish to be truly free. The social atmosphere of the elite automatically prepares them for honorable communication and exchanges with any other individual. They live their lives in the understanding of the fundamentals of law in general, and of course in logical skill through ancient understandings and philosophies such as the 7 liberal arts that guide them in their dealings. These people never react. They prepare for and respond to all of their daily affairs. Such were the creators of the Magna Carta, prepared on every level to operate effectively outside of the same law structure that they created themselves. And these people and the descendants of their philosophies have been, are, and will continue to be in possession of the arts of the clockmaker for as long as humanity refuses to understand the world they live within. As long as someone has a need to be controlled, there will always be a clockmaker to help regiment the man into order and harmony with others. And logic will tell you that the word government stems from the word govern, which means to steer or direct or to control. What's being governed? Your mind. Ment is the root of the word mental. And in all cultures that use this word in all its variants, it has to do with the mind. If you lack an ability to govern yourself, other people have the right and the duty to govern over you. And with that in mind, think of the barbaric actions of many people with their violence, lack of morality, and general apathy towards anything but themselves. It's obvious that government is priority. But what is never told to the public is the highest government is self-government, the ability to reason, respond, communicate, and respect. There is no other need for external government except in the cases of ignorant or combative people. The reality of the situation is that law is a measure of the man, and the court uses instruments on you, don't they? Instruments of reason and logic. Instruments of paper, claims and motions. It's live theater in the most minute detail, debate and argument. But the most interesting thing that you will find in law is that all previous things that happen and future events that have not taken place are legal fictions in law because there is no way to consider them in the current real time. These events cannot be practically introduced to the court in real time. Instead, law must measure the logic and honorable intentions of each party and try to find defects in one or the other to find a determination of remedy. And it speaks to the fictitious nature of law itself, as it deals only with dead corpus bodies or entities. These fictions are at either end of the time spectrum, either the past or the future, while the individual is being measured in present living time. You can see the logical conflict with just this one aspect of how law works. This takes us into our last foray of exploration in the different law types. It's called the law of waters, or maritime admiralty law. Even with common law in place, there are other types of interaction that can be formed at yet another level of rule. It's an international system of law that was formulated specifically to secure and ensure corporate interests. It allows for a fair system of trade and commerce between communities. The history of this system is related to losses at sea of large investments of vessels and cargo. The large financial powers of the ancient world combined a system of commerce under specific rules of operation and funded most of the large shipbuilding and wages for the seamen. They realized the value of insuring and providing the capital for the operations of ever larger companies. Anyone who works for these companies, all of the employees, must also operate under the rules of this commercial system or code of conduct. And as most shipbuilders didn't fund their own construction, they became employees of the system as well. Farms that began as investments, or lands that were mined with the funding from these sources of large wealth would flourish, but ultimately, all people involved with the property were subject to the debts they owed to the financial backers. The original tribute to the king had now shifted to the companies backed by the system of freedom that their philosophical ancestors set up for them. This is not to say that monarchies were no longer in power. Instead, it gave each king the ability to also exchange and communicate with the people through commercial practice rather than direct rule or slavery. Maritime admiralty law, or the law of waters, is the ultimate source for the commercial system in place today. Through the Uniform Commercial Code, or UCC, and the United States Code, or USC, the United States exists as a corporate entity, just like any other corporation that's under it. The law of waters has been brought onto dry land by the commercial consolidation of territories previously owned by sovereign people and their kings. Over time, the commercial interests with the most capital, many hundreds of years ago, figured out how to buy up rights to property and land through the creation of a system of credit that could be extended right now, backed by the future repayment of labor or resources plus interest, also called usury. Wars had to be funded, and it was the same group of financial backers who funded both sides of almost all historical wars of the last few hundred years. This was done to bring a new system of order into existence, one controlled by the markets instead of tyrant kings. As long as you accept the commercial colonization scheme of maritime admiralty law, as the British seemed to master during the 17th and 18th centuries, your country would be funded and wars could be waged. The commercial system used the nations of the world and the public of those nations to promote the fostering of maritime admiralty law, industry, consumer products, and a monetary system, to the point of dependence on those systems. This is why we deal with commercial courts today, and this is why the concept of the straw man is not so far-fetched after all. All participants in court are considered actors. Do you find that interesting? How about the supposed judge in court? Is that guy up there on the bench really a judge? Why is his title actually defined as a magistrate? A magistrate is a glorified court clerk. He does not demand anything and can only work with the information provided by the two parties. It's also clear that the word magistrate is a compound of the word magister, which meant master or magician, and the word stratus, which is the root of the word stratification or hierarchy. So this judge is the master of hierarchy. Remember the pyramid form discussed earlier? It represents hierarchy in a simple way. And now you're ready to understand why the idea of all men being created equal and having natural rights is a non-existent thing within law today. Because for there to be hierarchy, that means that somebody is of greater power or influence. It means you do not have equal standing among other men. Any stratification of men results in inequality to most, and the spoils acquired by the very few at the top. So those who accept and believe in social status in any form automatically fall into the jurisdiction of these magistrates. And so do those who trust in another man's performance to represent them in law, as a lawyer would. Anyone who is represented has accepted someone else to speak on their behalf. This means you have given up the ability to speak for yourself. It's a lack of an ability to respond in your own capacity. You have become a child in the eyes of the law, and their parental authority will guide you in any direction that they deem fit. You accepted their offer of authority the moment you answered to your name or straw man. In this way, you are under the jurisdiction of law simply by accepting the offers or the questions that they may have asked you. Why would a man claim to be an adult and yield to the authority of other people as a child would? The ignorance of the average individual is expected, and so each individual is given a governing authority until they reach intellectual maturity, and most will never achieve it. For this reason, it's very important to set up institutions of indoctrination, propaganda, welfare, and law to deal with the vast majority of governmentally bankrupt people who are born. To top it all off, I haven't found a single reference to actual real time in any United States code or uniform commercial code. This is further evidence that all of these supposed maritime admiralty laws, which are really just statutes or policies, only affect the dead corpus entities or legal fictions and cannot deal with direct presentation of the individual in real time. You can see the Clockmaker theme here too, especially where many people focus on the past or the future more than the most important time of all, the present. The right now present time is the only true and real time, which is why the past and future need to be fictionalized in the first place. Probably why the past and the future are so reinforced in our social lives to keep us dependent on those aspects having some sort of reality. It makes the present time less important if you long for the past or if you look forward to a future. It binds us into an ordered and predictable state of mind, and it allows the force of law, their law, to be imposed upon us all.
They get your signature on documents with the word application, submission, registration on everything, your car, your property, your children, for Pete's sake. When they do this, a legal title is transferred to them. What happens when you register your kids, and they do not tell you this, but I can prove it step by step, you are generating a legal entity for your child, just like any business has a legal entity. You're associating it with your child, you're abandoning ownership of that, signing it over to the government by an act of registration. Now they hold on to it, and they let you keep your kids, and they don't tell you about it, but when they come to remove a child, it's that legal entity that they're removing. You can just hand them back their birth certificate and say, here's what you've got a right to, take that. There is so much deception. I've broken down and studied more acts and statutes than you can shake a stick at, and I have found more deception. Your social insurance number identifies you as a federal employee. Now, does it make sense that we would have rules for those who are federal employees, and those rules would not be applicable to people who are not federal employees? Does that make sense? In Walmart, you'll have rules for the Walmart employees, but they wouldn't be applicable to one of the shoppers. Is that correct? You buy that? What they've done, all these acts like the Controlled Drug Substance Act, Liquor Licensing Act, all of these acts, they apply to you because you have a social insurance number and you are an employee of the federal government to a large degree. That's one of the things I found. Now, I've been doing a little social studying online in this forum. A lot of people hate this. They think that I'm anti-government. We're actually just pro-good government. They think that we're anarchists and that we're going to destroy Canada. I personally think that Canada is destroyed. The concepts that made us great, these are destroyed when we stop thinking for ourselves and start just blindly obeying. There are only 3 ways I found to break the law: harm another human being, damage someone else's property, or use fraud or mischief in your contracts and your dealings. What they do is they get you through the act of submitting an application, usually for registration, into a contract, the terms of which are found in all these acts. They are our servants, and they have tricked us into wearing the aprons, and it's about time we start acting like the masters. The name you use now legally hasn't changed since you were an infant. That name identifies your status. They look at you as a child of the province. There is a status at law which refers to people as a child of the province or a ward of the state. This is the case because you have not changed your status since you were an infant, and they get to treat you as such. What I found in deconstructing the Criminal Code of Canada, the thing is they have to put it there. But then they hope that they can create a language that is so complex, so crazy and seemingly illogical that we never even bother reading it.
In our country, when it started out, it started with an incredible, a profound concept. They said, no, we hold these truths to be self-evident that all men, not just the kings, the individual kings of England and France and Spain and so on, all men are created equal and endowed by their creator with certain unalienable rights. With that statement, they made each of us an individual sovereign. It's borne out in Chisholm versus Georgia, 1793. Supreme Court of the United States declared this is to be a nation of sovereigns without subjects.
Well, this is the fight.
Rights for God. That makes the government our servant. If you and I are sovereigns, the government is our public servant. If you and I are animals, the government is our master.
And notice they don't use terms like public servant or peace officer. It's law enforcement. It's official. It's authority. This is just nothing but modern slavery where they are above the law, they don't pay taxes, they do whatever they want and don't follow our original just laws, and then they make unjust laws for us. This is the essence of tyranny.
They say we have to obey their law, but they don't have to obey our law. And again, the hierarchy is God's law, number 1, we the people, our law, number 2, and that's the constitutions of the states and the federal government. And finally, we have the government's law. That's number 3. They say we're always subject to that, but they don't want to be subject to the people's law.
It works exactly the way it was planned to work, because this goes back hundreds of years. This is not something that's new. And there's courts of justice. How many people in this room have suffered at the hands of the courts of justice where injustice is actually happening. What I'm going to tell you today is that the members of Parliament are actually directors of a corporation. That is what you're elected. And because you're only electing directors of a corporation, nothing will ever change. It will go in the same direction forever. Because politics is not what you think it is. The members of Parliament, anybody seen this before? This is Dun & Bradstreet. Do you know what Dun & Bradstreet is? Right. If you were going to do business with a corporation or a company in the world, then you can use Dun & Bradstreet, which at the moment is about 160 million corporations worldwide. You can use these to find out if that corporation does good business. Does it have any debts? Has it got any county court judgments against it? So what this is a register of corporations, of companies. And the members of Parliament are a company. Gordon Brown is a company. David Cameron is a company. And this one I like. The Labour Party trade as Alistair Darling MP. It's their trading name. It's just there. The reason they trade with Alistair Darling MP is because Alistair Darling is a diplomat. There's about 3 of them. If they trade in his name, that trading name has diplomatic status. That means they can bend things and do things that you don't know about. It's a whole different way of doing things. This is what politics is about. This is what you believe to be the people representing you are doing, but they're not. This is what they do.
So in the 1850s, the government, I don't remember which city it was, but the government brought out the military and escorted the first children for the first mandatory public school. And that was the beginning of the public school system in the mandatory sense. There were public schools, but that was the mandatory public school. Now, why was it so important? Well, they couldn't change the Constitution. There was too much resistance there, so they changed the education system. From the 1850s to the 1950s, they stripped out the subject of civics and replaced it with a new subject that you're all pretty much familiar with. It's called American government. You ever take that in school? American government? Social studies? Okay? They took out civics. What is civics? Civics, if you look in the dictionary, at least the one I looked in, civics is the study of personal rights. It's that branch of political philosophy dealing with personal rights. Well, once the government gained control of the curriculum, they stripped out the things that were troublesome to government. Things like your rights. So here we are again, okay, all of us basically are studying civics. That's really what we're doing when we go to court. Now, so like I said, from the 1850s to the 1950s, they stripped it out. That subject is there, phased it out little by little. So from generation to generation, there might have been a deterioration, but it was not that visible what they were up to. But if you compare 100 years ago with today, or 150 years ago, you can see the difference.
The international bankers own it all. There isn't any land in this country, there's no national parks and forests, there's no birth certificates, no corporations that are not owned lock, stock, and barrel by the international bankers. The titles, okay, are owned. They've been transferred as collateral to the international bankers, these stocks and bonds and securities and all of that. All of the nation states of the United Nations are bankrupt. It's one of the conditions of membership, by the way, of the United Nations. You have to be a bankrupt country. Otherwise, you can't be subject to being controlled. Now, can you? When you become bankrupt, you transfer your sovereignty, because you stole it from the people, right? You stole your sovereignty from the people in the states, and now you basically hand it over to the creditors to direct the affairs of the nation.
Don't underestimate these people. These people think in 100-year terms or 200-year terms.
Do not represent yourself. You are either present or you're not? How do you represent yourself? Represent yourself? I don't think so, folks. You come in your own right, and those of you with a law dictionary, Black's Law is probably legal dictionary now by the time they've edited it. Black's Law will tell you, coming in your own right. Folks, you want to look at the term sui juris. So you come in your own right. You don't come in representation of yourself. Sounds kind of dumb when you think about it that way. But you have the right to present yourself before the court in your own cause. And you also have the right to determine that authority of that jurisdiction. And I say this with a little bit of authority because if you don't do that right off the bat, in other words, if someone sues you and you don't immediately come in and challenge the authority of the court, the jurisdiction, the substance of what's going on before the court gets jurisdiction, you've waived all your rights to be present and to avoid. And you then become represent of the fiction that they've created to get you to get a hold over this issue that they've created. And in legal, that's all you have. Legal is documents of an interest to property, not the possession or actual authority and jurisdiction in it. And that's how they're essentially doing all this. They're doing it on legal fictions, and no one knows how to really bring it up. But let me suggest to you, folks, that's what I keep telling you. That's the rabbit hole. And guess what? It's a commercial rabbit hole.
The law demands a precise method of communication between all parties so that they have clarity of the words that they use. To facilitate a clear understanding of law in the words used, a default definition of each word must be formed and written under the agreement of the law society, the courts, lawyers, and the bar as a whole. Various law dictionaries are available in different revisions based on common usage of the words during the time that the particular law dictionary was written. The best law dictionaries are the older ones. It's good to have a newer one and an 1800s edition as well, but the older ones aren't as cryptic and they have fewer circular reasonings in them. You will find the words in a law dictionary such as a Black's or Bouvier's law dictionary to appear written in English, but the phrases and definitions of words within it are much different than normal English definitions at times, and occasionally the words will actually have an opposite definition. This leads to incredibly confusing interpretations of what legal words and terms might mean, and therefore the intent of the words is lost. For example, I've found a few highlights from my Bouvier's 6th edition to offer you. This law dictionary was published for 1856. One of the definitions for credit contains the words, influence provided by intrigue connected with certain social positions. Do we see another reference to a hierarchy here? And the word intrigue, what's that about? Could it be related to the word scheme? How about creditor? Bouvier's has this to say about it. A creditor may be divided into personal and real. Why is there a division between the personal and the real? Because a person is not you. Further research will show a person to be a man considered according to the rank he holds in society, with all the rights to which the place he holds entitles him, and the duties which it imposes. If you are a person, then you automatically give up the right to be equal with others, for the possibility of a higher or lower status than other men. For this benefit, you must be obligated to the duties that it imposes. The person could be defined as the legal fiction or the straw man itself. A person is a corporate entity, a placeholder or a game piece on the Board of Commerce. Lastly, I'd like to offer some of my favorite Roman law maxims, as they are quite revealing in their content and equally important to the foundations of law, and also can be used to take precedence over any commercial statute or code if properly worked into your logical presentation. He who does not deny admits. One is not present unless he understands. He who considers merely the letter of an instrument goes but skin deep into its meaning. A fiction is a rule of law that assumes something which is or may be false as true. Let him who wishes to be deceived be deceived. Legality is not reality. Legal remedies are for the active and vigilant. The status of a person is his legal position or condition. A person is a man considered with reference to a certain status. What is mine cannot be taken away without my consent. The claimant is always bound to prove. The burden of proof lies on him. These are their laws at the very foundation or core of it all, and they show how law attempts to weigh the two concepts or presentments in the court. A magistrate is tasked with the usage of these maxims at the foundation of man's intents. Magistrates would serve as excellent psychologists, and it's no accident. Arrogance or violence in the people shines through in their words and their actions. The judge is trying to find the man that is more honorable, logical, respectful, and equitable. We've simply been ignorant to the way commercial law was designed and how it operates.
Yeah, bitch, you're fucking done. Hey, what is it or what? Dude, look at we fucked those people all the shit down there.
Dude, those two people?
You see who pulled up in the white car? I shot that dude in the white car, ran into the fucking building.
The end is near, and all these people, they will learn to stop worshiping Allah and start worshiping the 2,000-pound JDM that's about to fuck their whole world up.
Did you see that? That is fucking sweet!